Nine ayes, 0 nays.
Senator Spruill's coming in, Senator Ruff's coming in, Senator McClellan is in agriculture, but I think we have a quorum, don't we? Okay, the plan is to take up the criteria bills first, and if we adopt one, the others will be out of order. The first one we're going to take up is Senator Barker, or is that Senator Lucas?
No, actually, Senator McClellan has the bill.
She has the bill.
The bill, yes.
Okay.
We've all been working on it.
Okay, well then, we're going to suspend for a second and wait for Senator McClellan to get over here. That was the plan, was to knock these bills out first and then get on with the rest of the docket. Well, why don't we do this? Senate Bill 74 and Senate Bill 166, is that the Saslaw bill? Did he want that taken back for the day? Okay, well, he asked me if we couldn't just take that up Senate Bill 166, I direct your attention to that bill. It amends the current laws regarding disbursement of surplus funds. Basically, it prevents private use of campaign dollars, as I understand it. Understand its purpose. So it would prevent you from going through, say, a Burger King drive-through and using a credit card from your campaign credit card to buy your supper. Or go to the grocery store and buy groceries with your campaign funds.
Mr. Chairman? Mr. Chairman?
Senator Spruill.
I have an annual breakfast every year. And we go to Sam Club. We buy, since Lucas has been there. No, no. I said you been to my breakfast.
Well, that sounds like a campaign event, or
no? But every year, I have an annual breakfast every year, and we go to Sam Club. We buy all the pancakes, all the sausages, and all the syrup. And we're doing this for 20 years, and I use the campaign card. We do that once a year. So you saying that with this, then you saying I can't do that?
No, I don't think that's what it's saying at all, Senator Spruill. I think what you're talking about is an event related to your office or your campaign, and I think that would be all right under this bill. I think what this is aimed at is conduct of using your publicly the dollars that you have to disclose to the public, your campaign dollars for private purposes.
Mr. Chairman.
Senator Servell.
Maybe counsel could correct me if I'm wrong, but I'm pretty sure the way I'm reading it, this only applies to what happens when you shut your account down, not what happens while you're still actively filing reports and still campaigning. Am I right about that?
Mr. Chairman, Senator Servell, that's the case with the current law. What this bill does is takes that provision regarding the personal use of campaign funds and removes it from the final report section so that it would apply throughout the life of a campaign.
Got it. Thank you.
Mr. Chairman, I would.
Senator Bell.
I would say that lines 149 to 151 describe that. Unlawful for any person converting contributed money, securities, or like intangible personal property to personal use or member of their immediate family, et cetera.
Okay.
Mr. Chairman.
Senator Servell.
And, so Senator Spruill and I are here talking. So, first of all, I spend all my campaign money on campaign stuff, but I've often, when I've looked at the reports, been marveled at how much money gets spent at places like Sheetz and McDonald's and some other places. And, every once in a while, I've taken out my session interns for dinner at the end of session to thank them for serving, although I don't think I've ever used campaign funds, but I think some people might.
I do.
And, okay, well, Senator Spruill does. And so I'm just curious, if we were to pass this, how how one would know whether or not a dinner or a cell phone charge or whatever was personal or campaign related from looking at the report.
Well, I guess, it depends on your definition of the term personal use.
Mr. Chairman,
I would argue that if it's related to the campaign or the office, it's not personal.
Mr. Chairman,
Senator Spruill.
I want to tell the truth of mine. Whatever I do, I report it. If I'm getting busted for it, then fine, but I'll tell the truth. Now, I have a staff of 5, and when they do a good job like that, then I take the staff of 5 out to dinner, and I reported it. Current staff out to dinner and the amount and where I went at. So that's my question. So then if someone says, Spruill, you can't do that, that's wrong, then okay, I'm wrong, and I made a mistake, and I have to pay for it. But I'll tell it. But I don't want to have to lie and say, because I want to carve, when we leave here, I want to cut my staff out to dinner and lie about it. I want to tell the truth about it. I take them out for dinner. If they do a good job, the section's over, I cut 5 staff members out to dinner, and I reported exactly where I go and what I spend it for. I cut them to dinner because they done a good job. I don't take my girlfriend or my friends out to dinner. I'm talking about people who work for me. When they do something good, I cut them out for it, and I report it just as it is. And so that's my thing. It's that. Dick Slash, bless his heart. I don't know what he mean by doing this, Mr. Chairman. I can't vote for this. Now, I'm hoping that he would be here to explain what he was talking about.
He's not going to be here. Are there people in the audience who would like to speak in favor or against the bill?
Mr. Chairman.
Mr. Chairman.
Senator McDougal, then Senator Howe.
Mr. Chairman, I don't know who to ask this to, but I want to take Senator Spruill's example. So Senator Spruill has his annual breakfast, and it says personal use, so it's for fundraising. He's at the breakfast. If he drinks a cup of coffee for which he purchased it there, isn't that not him converting that to personal use?
Well, I guess, Senator McDougal, it's a matter of definition. It sure sounds like somebody could argue that, but I would argue if it's at a campaign or event or some event related to the office, it's not personal use.
Well,
But I'm not sure if it's defined anywhere in the code or in any case law.
Mr. Chairman.
Senator McDougal.
As you go to court as frequently as I do, so when you're talking about personal use, I don't know that there's a limitation on what that means. So I think a reasonable reading of this is if you're at your campaign function that's for fundraising and you consume any items that were purchased for that fundraising event, that would be converting it for personal use. I don't know that was the intent of Senator Sasslaw, but I think that's what the words say.
Well, I think Senator Howe's got a question or something.
Well, I was just going to try and draw a distinction. It would not be personal use if you took your 5 interns out to dinner, because that would be related to your office. It would be personal. It would be, though, if you were to take 5 of your family members out for your birthday. And I think that's the distinction this bill is trying to get at.
That makes plenty of sense to me, but I'm not sure it makes. Senator Eben.
Yeah, and I want to oppose this to Senator Vogel and to council. Senator Vogel has had a bill in past years that unfortunately didn't make it through, that I don't think it used the word surplus. I think it was for current funds. And I was trying to figure out if this is just about funds when you close your campaign down, or, go ahead.
We've already had that discussion.
I had that question. Yeah, question.
Okay.
What Meg explained is this takes it beyond that to throughout the campaign. And I think Senator Bell pointed out lines 149 through 151 of the bill contains a specific language that.
Yeah, I guess, Mr. Chairman, I was just having a problem with the word surplus.
Meg.
I was just going to say, Senator Deeds, rest of the committee members, I believe what Senator Sasslaw was trying to do with this bill was take the law back to what it was pre-2006 when we had the Campaign Finance Disclosure Act. The language that you see in the new code sections throughout the bill used to be their own standalone code sections, and then during that mini recodification, they were added to the final report requirement. And as a result, we had an attorney general, not an official opinion, but a written guidance document that said, this means that all of these rules only apply in the context of a final report requirement. If it was meant to apply through the life of a campaign account, then it would be in a separate standalone section. So he's just trying to take the law back to what it was pre-2006.
Okay. Senator McDougal.
In Senator Howe's example, I think she's 100% accurate about the interns, but if Senator Spruill is eating with his interns and he takes, in his part of the food or beverage is included in that bill, doesn't that make him in violation of the statute? So he could pay for the interns, but he couldn't eat at a fundraising event or at that without being in violation of this. I think the way it's written is what I'm asking the question.
Mr. Chairman.
Senator Surville.
So, I mean, I think the problem that arises is the ambiguity associated with personal use. So, for example, I know there's, at least the Washington Post used to love to editorialize about a particular member who's no longer with us because of the amount of dinners that particular member seemed to take using his campaign fund and other things. And the problem with the bill, the way it's drafted, is that it doesn't distinguish between personal use for sort of senator, delegate related stuff versus personal use with your family. So, for example, that one member who's no longer with us, I think, at least what I read, was that they used to take government relations people to dinner using their campaign fund, and or maybe other people, I don't know, or they would pay other expenses. So, for example, if a member decided they were going to use their campaign funds to pay for going to the Homestead for a caucus meeting, are we eliminating that? And because the statute does not differentiate between personal use for things you have to do as a member versus personal use that has nothing to do with your member, it creates that ambiguity, which could potentially open up all of anybody elected in the state, not just us, but locally elected officials, to criminal liability because of that ambiguity, and also just PR issues. I mean, I could see opponents or newspapers or other people just taking the language and using it like a sledgehammer the way it's drafted. And so the bill is written, I think it's well-intentioned, and I agree that we shouldn't be able to use campaign funds for eating out with our families. There's no question about that, but I'm not sure the bill is drafted really is narrowly focused on that.
I hear you, Senator Surville. Let me ask Meg a question. You said this was taking us back to the pre-2006 code. Is this use the same language we had back then?
Mr. Chair, it does. We didn't have a definition of personal use back then either.
Okay, so the problem existed prior to 2006. Was there ever any case law on it that defined what personal use was?
Not that I'm aware of, no, sir.
And do you know how long it was the law prior to 2006?
I do not know that either, sir.
Okay, thank you. The bill is before the committee. Is there further discussion or are there motions?
I move to carry it over to 2021.
Substitute motion. I move to PBI.
Is there there's a second on the substitute motion? Okay. All in favor of PBI? Is there any discussion?
Mr. Chairman, a quick.
Senator Surville.
I would wonder if my seatmate here would accept as a friendly amendment that the chairman write a letter to the State Board of Elections to see if they could come up with a way of differentiating true personal use from campaign personal use
Yes,
for
sir.
purposes of a future
Yes, sir.
bill.
Yes, sir.
Okay.
Mr. Chairman.
You might ask him how they defined it prior to 2006, too. Yeah, Senator Bell.
Mr. Chairman, in that letter, and I'd be happy to work with you offline on this. I also think we should do a little bit, ask them for more of a definition on excess funds, because I think there's a little confusion on that as well.
Okay, and that's an existing law. That's not excess funds and surplus.
Well, we talk about excess funds in this. I read it, if you're discontinuing a campaign versus if you have your ongoing campaign account, I think that's a little bit of a different thing. Because
Well,
it's really questionable what is a campaign expenditure and what isn't. A lot of gray area in there.
So the motion is the PBI with a letter. Vote yes if you're in favor, vote no if you're opposed. Open the roll, please. Okay, the motion fails. We go back to the substitute motion, which was to carry over. Was there a second for that motion? Second. Okay, there's a motion to carry over and a second. Is there any further discussion?
Mr. Chairman, could we do the same letter with the carryover? Okay.
Mr. Chairman, Madam Clerk fussed at me for making that same motion in rules earlier in the week.
And I was there when she fussed.
Yes.
Yeah.
All right.
Maybe the chair could write a
Okay.
postcard as well.
Yeah. How about a postcard?
Okay. All in favor of carrying over, vote yes. All opposed, vote no.
Thank you.
Okay, the bill is carried over. I've got two miscellaneous bills on the docket here. We're still waiting on Senator McClellan. 175, which is Senator Chase's bill, is also a criteria bill. Is that right?
It's a redistricting, but it includes the political data.
Well, let's wait for Senator McClellan to do the criteria stuff. 131, is that your bill?
Yes.
Okay. Sure.
Excuse me, Mr. Chairman, does Senator McCullough realize she need to come over here?
She's on her way.
Okay, thank you.
Thank you, Mr. Chairman, members of the committee. I'm going to cut to the chase for you. This bill has to do with constitutional officers. Some don't want any type of designation at all because they realize this is a local seat. I don't want any type of party affiliation on there, and this bill respects that. It actually gives the constitutional office, whoever office candidate that's running, many choices. They can choose to run as an independent like they have for years. By the way, and I would like to adopt the amendment in the nature of a substitute.
There's a substitute for, do we have have a second? All in favor of adopting the substitute, say aye. Aye. Opposed, no. Okay, the substitute's before you.
Okay, thank you, Mr. Chairman. I'm trying to make this as permissive as possible. So it gives the constitutional officer the ability to run for their party's nomination, whether it's Republican, Independent, and even after securing that nomination, they can say, hey, I don't want to put that indication on the ballot. It's a choice. But if they want the option to have an R or an I or D by their name, they can do it. So it really does give the discretion to the constitutional officer. Sometimes it benefits them to have that party designation. Sometimes it doesn't. But the only way you could actually have any type of party designation is if you want the nomination and you want the indication by your name. Otherwise, you don't have to have it on there. So that's, in essence, the bill.
Okay, the difference between the substitute and the bill as introduced is the bill as introduced said if you were nominated by one party or the other, you had to be identified that way on the ballot, and this says you may be identified.
Okay.
Leaves it up to the candidate.
It's all about the candidate having the
Chairman.
choice.
Okay, I think we understand, yes. Senator Spruill.
Let me use, for example, the city of Norfolk, the sheriff, the city of Norfolk, and Alan Krasnoff. What is he, the treasurer? Chesapeake. The sheriff of the city of Norfolk, he had to run in a Democratic primary to get the nomination. But then election time come in November, he could not be put on the ballot as a Democrat, which almost cost him the election.
This will allow them to do
Because
that.
Norfolk is heavily Democratic. So my question is that why would you have to allow him? You must run it in somebody's primary, but you can't put on the ballot what you're running for. So my point is this, in my personal opinion, if you run as a Republican, you should be a Republican on the ballot. Run as a Democrat, you should be a Democrat on the ballot, not try to hide it. because it was not right to have the sheriff in Norfolk that had he not ran in the Democratic primary, he wouldn't be sheriff. He had to do in the primary first, and then when the election time comes, all the election officers, including the senators and the delegates, all on the same ballot, but he was down here below, and they said, why is the sheriff not a Democrat? He is a Democrat, but he was not allowed to put Democrat on the ballot.
Okay, I think we understand how you feel, Senator Spruill.
Mr. Chairman, Senator
Senator
Spruill,
Chase.
you're going to love this then, because it gives that sheriff from Norfolk, if he secures the Democratic nomination, it gives him the option. He can put the D by his name, or he can choose, I don't want to do that. It's his option. It's
Okay.
a transparency bill.
Transparency, low information voter bill, I think.
We have a few in Chesterfield.
I understand
Colonial Heights
that.
and Amelia. They're great voters, but they're busy. They're working, right? Let's help them out a little.
Okay. Are there further questions from the committee, or are there people here that would like to speak
Got
to
one
this bill?
question, sir.
Senator Evans got a question.
How is a transparency bill if you could either say what you are or hide what you are? How is that transparent?
Thank you, Mr. Chairman. Senator Evan, point taken. What I would say is that this is more transparent than what we currently have. In working with all the players, I've introduced a similar bill 2 years in a row. It was shot down because this is a move in the right direction. I would love to see the bill that you're talking about, but that is not the bill that moves forward from this committee. The localities want the option not to have any party label on there at all, and I think this is a move in the right direction. I welcome your amendment, but that's just where the committee is.
Okay, are there people that would like to speak to this bill?
Mr. Chairman, Alan Albert on behalf of the treasurers. I don't know if you wanted to take those in favor of the bill first. I don't know that there are any, but I'm actually going to speak against it.
Yeah, whoever, are there people in favor of the bill? I'd like to hear from them first.
Right.
I was just going to offer a clarification that it's a ballot standard issue. I'm Liz Martin, General Registrar of Voters for the City of Winchester. And if I'm not mistaken, this is a ballot standard issue that when you run affiliated with a political party at the local level, the party designation is not beside your name on the ballot at all, even though you are affiliated with that party. Otherwise, you are running as an independent and you're required to get petition signatures. Okay, so, yeah, I just didn't, from the conversation, it wasn't clear that everyone was grasping that there is no party designation. That doesn't mean you're not affiliated.
We've seen these bills before.
Okay.
Oh, I'm sorry. Sorry.
Clever Wheeler, Albemarle County. This is a choice bill. The way the code reads now, as Ms. Martin just described, if a candidate goes through the trouble, the choice of having a party nominate them either by primary or by convention or caucus, I'm not sure I'm supposed to say that word today, then that person may be a Democrat or a Republican, but on the ballot standards for a local election, they may not put a party designation by their name under the way the code is now. This bill gives them the choice. If they want to have the party designation, they may choose to do so. So in Senator Spruill's example, if they choose to not have a party designation, even though they've been nominated by a party, they can just have nothing by their name. It's the choice of the candidate. Thank you.
Okay. Now, Alan.
Mr. Chairman, I'll be very brief. We very much appreciate
Treasurers
Association. I'm sorry. We very much appreciate Senator Chase working with us. This bill, as it went in, was mandatory. Obviously, the substitute is optional, and it does give the option. Of course, if that's a good idea, you might want to apply it to the General Assembly too. Political winds change, and there may be some years you don't want to be on the ballot with a party designation, depending on where you're running. We'd still respectfully say to you that we prefer the statute the way it is, which does not carry a partisan designation for any of these offices, they're not really partisan offices. They do.
They are partisan too.
I appreciate
You
your
got to appreciate. I
position.
know what I'm talking about.
I know you do, Senator Sproul, and I appreciate your position, but 53% of all constitutional officers run as independents now. For the treasurers, it's over 60%. There are only 24 treasurers in the state that run as Democrats, roughly, and about 24 Republicans. And these offices perform core functions of government that are just not terribly partisan. You know, running the jails, running the courts records, collecting the revenues, assessing the properties in the state are not partisan policy-making positions. So we actually prefer the statute the way it is. Senator Chase is absolutely right. This lets everybody choose their own poison. And it's much better in that regard, but I would be remiss in what I do if I didn't tell you that the treasurers actually would prefer no bill to this bill. Thank you.
Appreciate it. Thank you. Is there anybody else? Okay. The bill's before the committee.
Mr. Chairman, move the report.
We've got a motion. Is there a second? Second. Got a motion and a second. Are there other motions or is there a discussion? Okay, open the roll. All in favor, vote aye. Opposed, nay.
Give me a second. I'm voting a proxy. I'll vote yes.
No kidding.
Okay, the bill fails to report. Thank you. Is there a further motion? The bill fails to report. And Senator McClellan, I think, now has the criteria bill that we're going to take up. Senator McClellan, if you could give us your bill number.
What do you think?
717. Give your direction. Is there a substitute?
Yes.
Okay.
Sorry. That's you.
And 717 includes provisions from other bills, is that correct?
717 is identical to what will be in other bills. So
Okay.
what we've done, regardless of who draws the districts, whether it's an independent commission under the constitutional amendment, if it's an independent commission under statute, or the General Assembly.
The criteria is not contained in the constitutional amendment.
Correct.
So if the constitutional amendment passes, you're still going to need a criteria bill.
Correct.
Okay.
Yes.
You want to walk us through the provisions of it then?
Yes.
Well, adopt the substitute first. There's got a substitute before us. Do we have a motion?
Move to adopt the substitute.
Is there, all in favor of adopting the substitute, say aye.
Aye.
Any against? Okay, the substitute's before the committee.
So the crux of the bill is starting on lines 58. So again, these are criteria that would be in the code that would apply to whoever is drawing the maps. What we've tried to do is to ensure that we are, to the extent possible, taking politics and gerrymandering out of the process and having fair maps that keep districts contiguous, compact, complying with the Voting Rights Act and Section and the 14th Amendment, and keeping communities of interest together to the extent possible, respecting jurisdictional boundaries. And so the criteria start at line 61. So districts would have to be proportionate to the population of the district. They can go up to a deviation of 5%, which is the maximum allowed under law, under the case law. We did not set a particular deviation other than the maximum allowed by law. Districts would be drawn in accordance with the Constitution, the Equal Protection Clause, the 14th Amendment, the Constitution of Virginia, and the Voting Rights Act of 1965. This Part 3 is designed to protect the interest of minority communities and their ability to elect the candidate of their choice. We put this actually in the code in the event that the Voting Rights Act at some point is not reauthorized or is gutted, it does put how the Voting Rights Act is currently and has been interpreted by courts in place to enshrine that in our code. 4 is the district shall be drawn to give racial and language minorities an equal opportunity to participate in the political process and not to dilute or diminish their ability to elect a candidate of their choice, again, enshrining the principles of the Voting Rights Act in the code. Districts will be drawn to preserve communities of interest, and we have a definition of communities of interest, which I think is self-explanatory. Make sure that districts are contiguous and compact. And then that the map as a whole not be drawn in a way to favor or disfavor any political party.
Right.
And that we will use the census blocks as the basis for the population, or census for setting the population. The other thing that's relatively new here, I think, but is not new in other states, is reallocating prisoners. So what we're trying to do is avoid situations where districts are drawn such that prisoners who cannot vote are used to meet certain statistical numbers, but they can't vote. So to avoid that, and we think it's more fair to have them allocated for redistricting purposes at the last known address where they were before they were incarcerated.
So it's my understanding that for census purposes, they'll be counted as residents of their prison, of that locality, but for redistricting purposes, they'll be counted back home.
That's correct, and that's in effect is so that you can more fairly represent the interests of those prisoners, because they probably still have family back where they were, and I think their interest when they come out is going to be more aligned with the interests where they were before they went into prison, not just because they happen to be in Buckingham because that's where they were sentenced.
Sherman?
Senator Spruill, you want to wait till Senator McClellan finishes the presentation?
Yes, sir.
I think that's the gist of the bill.
Okay, but then Senator Spruill can ask his question.
Couple of questions, Mr. Chairman. Sure. The first question, you said self-explanatory. Not to me, what do you mean by community of interest?
So communities of interest are defined in the bill. On line 83, community of interest means a neighborhood or any geographically defined group of people living in an area who share similar social, cultural, and economic interests. It is not based on their political affiliation. So, for example, when the lines were drawn in 2011, the neighborhood of Church Hill is a community of interest. And so to the extent possible, you would try to keep that neighborhood together. Similarly, you may have an area that you do have some neighborhoods that are right next to each other, and they may have a political boundary going between them, but they're still a neighborhood. And so what this is saying is try to keep those neighborhoods together to the extent possible, consistent with all the other criteria.
Mr. Chairman?
Senator Spruill.
The second bill, I talked with you and Senator Lucas about my concern. I'm looking here, I want to know, how do I know that the committee put together, they're going to be fair? For example, I want to make sure that whoever put this thing together, somebody that looks like me that's on that committee.
That's not my bill.
And that's not this bill,
Right.
Senator Spruill. I mean, this is just the criteria.
Right, right.
We'll get to the constitutional amendment and the enabling legislation later. But that's not this bill. Are there other questions of
Mr.
Senator
President, I have a
McClellan?
couple.
Senator
Mr.
Servo.
Chairman, I have a question for the patron. So this system of counting prisoners for one thing but not for another, has that been litigated and found to be okay?
I believe so. I know they do it in other states. I don't know off the top of my head whether it's been litigated, but it has been done in other states. And Meg is nodding her head.
Mr. Chairman, Senator Servo, that's correct. There are a few other states that have this type of law in place. I'm not aware of any litigation that's resulted in any type of controlling case law for us.
Okay. Further question, Mr. Chairman?
Senator Servo.
Thank you. I appreciate that. It gives me a little comfort. I just remember that at least 10 years ago, whatever, 9 years ago now, whatever, there was one district that I think had 5 prisons in it that created some odd situations. So I also have a question about the communities of interest. So, the entire community of interest concept, I think, it might work in some parts of the state. I'm not sure how well it works in others. And just to take, for example, where I live, which I know Senator Barker's familiar with because he used to live there too a long time ago, but there was a house that sold my voting precinct for $20 million about a year ago. It was the most expensive piece of real estate that sold in the entire D.C. metro area over like a 7-year period. About Senator Eben, you would have been welcome to move down there because it's actually in your district, even though it's in my precinct. But in any event, about maybe a 7-minute drive, about half a mile as a bird to the west, you have the highest concentration of poverty and diversity in Fairfax County, and they all go to the same high school. And that's pretty much what my community is. One side of Route 1 is very different from the other side of Route 1. And so is that entire community a community of interest, or is one side of the road a community of interest and the other side of the road a community of interest? And I would just and also just point out that on the diverse side of the road, they're not all, it's a very, all kinds of people from all over the world are there, and all kinds of races and religions and everything. And
Mr. I think I fully understand your question. So if you read the definition of community of interest, it is a neighborhood or geographically defined group of people living in an area who share similar social, cultural, and economic interests. So it can be different sizes, but you're going to look at the smallest size where they would share similar social, cultural, and economic interests. So in your example, probably take the school example, the neighborhoods that are together that are more socioeconomically aligned are going to be, that neighborhood's going to be a community of interest, not necessarily the entire district that school represents. So again, here you can take, here in the city of Richmond, perfect example, Carver neighborhood and the Fan, and both are zoned for Fox Elementary, but Carver is clearly one community of interest and the Fan is clearly another. The idea here is to try to keep them together where possible, not say you have to group everybody who's the same in one district. It's keep Carver as a neighborhood together if you can do that, meeting the other criteria.
okay. Mr. Chairman, one final question I have.
Senator Servo.
I know that at least when it comes to compactness and contiguity, there's certain mathematicians that have come up with mathematical formulas, and I know that at least in your proposal, you haven't picked a specific number. You've sort of left it open and said using standard measures or something like that. And at least the courts, when they've looked at this, from my point of view, have basically treated compactness and contiguity like a joke. I mean, as long as you got stuff that's together, and I'm just curious about why we shouldn't put a number in there, an actual compactness or contiguity number, as opposed to just leaving it open-ended.
Mr. Chair, I think here we are trying to have criteria that would be broad guidelines and not so prescriptive that one might conflict with the other in a way that they'd both be impossible to meet. So I think we still, that's the same reason we said for the population deviation, you can go up to 5, but we didn't prescribe what it would be. And typically, again, depending on who ends up drawing the maps, they will probably, at the beginning of that process, come up with even more criteria that are more specific than this. Traditionally, when the General Assembly has done it, we've done that through a resolution. Presumably, if a commission would do it, one of the first things they would do is take this list and say, based on these guidelines, let's get more specific.
Thank you.
Are there other questions for Senator McClellan? Senator Chase, or I'm sorry, Senator Chafin.
Thank you, Mr. Chairman. Senator McClellan, has the Commonwealth ever taken a view in the past that you know of to exclude the prison populations from where they actually reside?
I was only here for one redistricting session, and that, as far as I'm aware, it was not discussed on the House side. I don't know if it was discussed over here.
Ms. Meg, haven't there been bills on both the House and Senate side in the last 10, 15 years that related to prison populations? The efforts were to exclude the prison populations from district counts, or?
Mr. Chairman, we've had not too many bills, but we've had bills like this before to provide specifically for the reallocation of prisoners from population counts. And then we did have a few bills a few years ago, and it's now in code to allow governing bodies of county, cities, and towns to elect to choose to exclude the adult inmate populations for correctional facilities that might be located in their facility. But again, that would have just been for redistricting purposes of the locality.
Senator Chafin's still asking a question.
Yes, sir.
Okay, after Senator Chafin's done, Senator Spruill.
Mr. Chairman, thank you. So, wouldn't you agree that those individuals that are incarcerated in those districts, they receive their medical services there, they receive any type of religious instruction, a myriad of services? That's where they're going to be getting them, is from that community. Would you agree with that?
I would agree with that.
Further question, Mr. Chairman.
Senator Chafin.
So even though they don't get to get out and walk around in that community, they're very much a part of that community, wouldn't you agree, more so than the other side of the state where they may have committed their crime?
I think I don't know that I'd agree, and for a couple reasons. I represent a lot of family members who live in the Ninth, who have relatives who are incarcerated in Buckingham or Sussex or Fluvanna. And when they try to reach out to the representative, if there's a problem in that prison, when the prisoner or their family have reached out to the representatives of those areas, they have not gotten a response. In particular, if the family members are reaching out, they're like, well, you're not my constituent. I have gotten inquiries from people in Sussex, Fluvanna, and Buckingham, where I have responded to their concerns because no one else has. So that's one issue we're trying to address. The second issue we're trying to address is if you have a district, and I think Delegate Rosalind Tyler's district is a really good example of this, where efforts were made to reach a particular number, but a significant number of the people in that district could not vote. And so because a significant number of people in that district could not vote, you are inflating the voting power of the other people in that district. What you are more likely to you're less likely to inflate or deflate voting power if you are spreading those who are incarcerated across a broader area than if you're concentrating them all in one or two districts. So those are the two reasons behind the proposal.
Further question, Mr.
Senator
Chairman.
Chafin,
Chafin.
apologize.
So Senator McClellan, the district that I represent, I believe, is the one that Senator Serville was referring to that has probably the most Department of Corrections facilities. Under these conditions, if this becomes law, then those individuals would be spread out. There would be this myth created where those individuals would be spread out across the rest of the Commonwealth. Am I right? They would not be counted in the district they actually reside in, but they would be counted in all the rest of those areas.
That is right. They would be dispersed into the districts where their last known residence was before they were incarcerated.
And further question?
Which would also probably give you more individuals who would count towards redistricting who are actually could vote.
So further question, Mr. Chairman. So
Madam Chairman,
You're going to get to go after he goes.
he's not in the courtroom. He can take up all the
But
time.
now, other people get to talk too, Senator Sproul.
I'm enjoying.
You got to let him go.
So, Mr. Chairman, so wouldn't you agree that some of these individuals, maybe a significant number, didn't even live in Virginia? I mean, we've got states all around us that people happen to slip into Virginia and commit crimes across the line from Maryland, across the line from Tennessee, from West Virginia, North Carolina, Kentucky, you name it.
So we try to address that at lines 106. So a person incarcerated in a federal, state, or local correctional facility whose address at the time of incarceration was located within the Commonwealth shall be deemed to reside at such address. A person incarcerated in a federal, state, or local correctional facility whose address at the time of incarceration was located outside of the Commonwealth or their address cannot be determined will be counted at the facility where they're incarcerated.
I thank the patron.
Senator Sproul.
Senator, since we done, Senator Robin Tyler was complaining that all of the prisons on that 460 corridor was in her district. And she was saying, let's say if you use the 80,000 number. She said, actually not 80,000 because they counted, they would reside in Sussex 1, Sussex 2, and another one on that district. And she was saying, so if you got 80,000, she said, but I don't have 80,000. Which, yes, you do. She said, you count those who are incarcerated in the number. She said, so really I have almost 65,000 because they were counting the 15,000 who reside on Sussex 1 and Sussex 2 and the other prison there. So is that what we're getting at?
Yes. So in Delegate Tyler's district, anyone incarcerated in one of the facilities in her district who we know their last known address and it was in the Commonwealth of Virginia will be counted there. So if they're, I'm just going to make up a number. I don't know. I'm a lawyer, not a mathematician, so I'm going to say 10. If they're 10, if they're 10 or 100 people in Sussex who we know their address is somewhere else, they will be counted somewhere else, and then you pull in an additional 100 that would be counted in that district so that you meet the population.
Senator Vogel.
Mr. Chair, there were just a couple of questions asked, and I'm just going to speak to this and hopefully provide some clarification on this. The underlying issue and the reason that this has been challenged, and it actually is the subject of litigation right now in Connecticut and has been the subject of litigation in Maryland, but in Maryland the court chose not to address it, is that this falls under the category of prison gerrymandering. And in every other category, when we do a census, it's meant to be a census, and we count people where they are. And the idea is that you're being fair to that locality, because that is, in fact, where they are. We do that with Navy personnel. We do that with university students. We do that with non-citizens. We do that with everybody else. In this case, as legislatures who are trying to influence the outcome of and to skew it a certain way, will try to say, you know what, we're going to change the way we vote the prison population, and we're going to suggest that it is better to have them counted where they came from, with the assumption that they might go back, that there's some connection there. And I think the idea is that it hurts rural areas more And it does have an impact in a way that people believe hurts the communities where those people are incarcerated. So that's the underlying issue, and that's the clarification and the answer to the question of, is it a subject of litigation?
Okay, thank you, Senator Vogel. Are there other questions? Are there people in the audience who would like to speak in favor of Senate Bill 717?
Thank you, Mr. Chair, members of the committee. Anna Scholl with Progress Virginia. We strongly support Senator McClellan's bill for a couple of key reasons. For a long time, the conversation around redistricting has primarily focused on who draws the lines, and while that is critically important, how the lines are drawn is also very important to the results and making sure that everyone in our communities is able to have a voice and choose representatives who will work for them. Senator McClellan's bill is very thoughtful in how it takes into account how we protect communities of color and communities of interest to make sure that we don't have similar situations to what we have seen previously where people of color have been disenfranchised in Virginia, either purposefully through Jim Crow laws and a number of other measures, and more recently through redistricting measures that were struck down by the federal courts. We think that's key for any criteria moving forward for redistricting, and also prefer to have it in state code instead of relying on the Federal Voting Rights Act, which we know has been systematically eviscerated at the federal level. And the final thing I would call out in this bill that we particularly prefer is that often in looking at criteria, the order in which the criteria is written in the bill is important for how is it interpreted in terms of primacy when two pieces of criteria come into conflict. And putting the protections for communities of interest and communities of color above the criteria for compactness and contiguity raises the primacy of those protections so that if they do come into conflict, we won't have a situation where it would be permissible to pack Black voters into districts to promote compact districts when it disrupts the ability of Black communities to choose a representative of their choosing. Thank you.
Thank you. Are there others who would like to speak in favor of the bill? Are there those that have a contrary opinion?
Yeah, I've got a contrary bill.
And I'm not sure you were here.
It's not going to be heard.
I'm
so
not sure you, what I was going to say, and what I said at the beginning is that if we adopt Senator McClellan's bill, the other criteria bills will be out of order. So the sponsors of those bills include, you on Senate Bill 56, Senator Barker on Senate Bill 241, Senator Edwards on 516, Senator Chase on 175. We can incorporate you and make you chief co-patrons of this, or we can just, your bills will just be out of order when this bill's adopted.
Mr. Chairman?
Yeah.
If it's
Can
adopted.
I address,
Mr.
my bill presents a very different position, and it's one that's been supported by majority of the current members of this committee in both the Senate and the members in the House when they were in the House. So I'd just like to present the alternative view that a majority of these members have previously supported.
You can speak to her bill,
All right, I will.
but that's what's before the committee right now. Senator Spruill's got a question, or he's got something
Mr.
else
Chairman,
to say.
but-
Senator Boyce
but
goes after that.
If he choose not to have his bill join into her bill, why can't we hear his bill separately?
Well, because once we've adopted criteria bill, we're not going to adopt a second criteria bill. They'd be in conflict. Senator Boyce, go.
Question, just a clarification question. So I know that there is a constitutional amendment still at hand.
Yes.
Would we be able to use this criteria in the event that the
Constitutional Amendment does not have criteria in it.
So we would be able to?
And I think Senator McClellan, at the beginning of her presentation, indicated that whether we adopt the Constitution, whether the General Assembly's drawing the lines or an independent commission's drawing the lines, we're going to have a criteria bill adopted.
Or the court.
Or the courts.
Mr. Chairman?
Senator Spruill.
But this committee, as far as having one criteria bill, is done on the floor. This is just a committee that recommends to the floor how you feel. So numerous of time we have seen companion bills on the floor, and they ask the companion to roll it in. But even then, even if we don't do that, but we still allow the other companion to say something about his bill, because if he chooses not, he does not want to, and his bill get out, then on the floor is rolling in dinner on the floor together.
Well, he is going to speak to he's going to speak to Senator McClellan's bill. Senator Spruill, there are conflicts between Senator McClellan's bill and the other criteria bills, and if we adopt her bill, the other bills will not be in order before this committee.
That's my point, Mr. Chairman, that we have in the past adopted two similar bills and we put them together on the floor. I don't know it's not a conflict. I haven't heard it.
Well, you haven't read the
Yeah,
bills.
I'd like to tell you about my bill. It's Senate Bill 56. It's been in the public domain, so that I'll speak to the differences between the text of the bills. It's been publicly available since, I think, the first day we were able to report it. Like I said, it's been something that's passed both the House and the Senate. When it passed the House the first time, it got 90 votes. 9 of the members of this committee had previously supported it. And on the content of it that's significantly different is Senator Serval was exactly right when he talked about a compactness requirement that's not actual a compactness requirement. And I'd suggest that the substitute for Senate Bill 717 that's before you is not a real compactness requirement. We currently have a compactness requirement in our state constitution, and several of you have heard me present before that I represent half of Hillsville, half of Wytheville, East and West Christiansburg, but not most people in Christiansburg, about a tenth of Rocky Mount, half of Carroll County, half of Wythe County, all of Floyd County, it's only 15,000, all of Salem, Roanoke County, which has 5 magisterial districts, and I don't represent all except of one of them. The others are all split. All 4 magisterial districts are split. Bedford County, which is adjacent to Roanoke County, I represent part of it, but not the part that's anywhere close to Roanoke County. You can only get to the part of Bedford that I represent to any other part of the district if you cross Smith Mountain Lake. I would suggest to you that we don't have a compactness requirement, even though we have something in the state constitution that says the lines will be compact. And I'd suggest a substitute before you goes down that exact same road again, and we're again going to have, if we draw the lines with that, we're going to have lines and districts that go from Arlington through Fairfax County that has 1 million people in it, all the way out to Loudoun. And again, we're going to split up localities. So I would suggest that you don't pass Senate Bill 717 and that you pass something like Senate Bill 56, which is what we've similarly done in the past. Another significant difference in this is by allowing a 5% deviation, that's really a 10% deviation. If we were to have adopted this plus or minus 5 last time, we would have some districts that would have been 180,000 and some up to 220,000. Now, what we did was plus or minus 2%. It shouldn't be getting, the larger the district, the easier it should actually be to have the district similar number. At the congressional level, they go almost to the person. And so having this, now that we're going to have districts that, obviously will be more than 200,000 as the standard, but then we have plus or minus, they're going to be deviations of more than 40,000 people. And I just point out the Senate Bill 56, the language there, if you want to be able to look at it to compare, that was the language that Senator Spruill's chastised earlier language, and I made sure that we were going to protect the Voting Rights Act and everything else in there. And that's why it had such strong bipartisan support the last 2 years.
Okay.
Quick rebuttal.
Well, do you want to finish up, because we still have a bunch of bills, and I've got kind of a real hard 5 o'clock deadline.
So 2 very quick rebuttals. What this bill does on the deviation is codify what is currently federal law. Federal law says you can go up to 5%. It leaves it to whoever is adopting the maps to figure out what percentage they're going to go to. That's exactly what we have today. As far as compactness versus, Senator Suderline's concern is that we're going to split communities together. That's why compactness is under keeping communities of interest together. That's why compactness is under the language that here is stronger in protecting communities of color and minority communities, because rather than just referencing the Voting Rights Act, we put the principles of the Voting Rights Act in the statute, so that if the Voting Rights Act is not re-upped, is it allowed to expire, or is further gutted by the courts, we are saying we want the full protections of the Voting Rights Act in our code.
Okay, thank you. The bill is before the committee.
Mr. Chairman, can I just say one thing?
Sure, one thing.
with my bill, Senate Bill 175, I think it's important that we also, thank you, Senator McClellan, we need to not take into account political data. That's what people in my district are saying. They don't want that in there. They feel like we are picking our constituents instead of the constituents picking us. And so that's my one request in there.
And on lines 84 through 86, a community of interest does not include a community based upon political affiliation or relationship with a political party, elected official, or candidate for office.
We're going to keep that in there.
That's in there.
Very good. Thank
Okay.
you.
Thank you. We've got a motion to report and a second.
Mr. Chair,
Senator Vogel.
I just want to speak to the motion, if I may. I very much want to be supportive of criteria. It's absolutely critical that we adopt criteria to accompany the vehicle, the Reform Commission, that we intend to adopt. But historically, as we've had this reform discussion, I have always voted, and I would like to vote for this criteria bill, but I've always voted for criteria bills that included language that respected the local political subdivisions. And that's to the point that Senator Suderline spoke about. And that's not in this bill. And that's the sort of, in my view, one of the core features of what I think reform needs to include. And so for that, I will have to cast a nay vote. But again, I think it's very important that we have criteria and that we should move the criteria in the right direction. And for the second reason, the conversation that we've had in and around protecting minority communities has been to preserve the Voting Rights Act and to protect majority-minority districts. And there are concerns, and have been concerns with similar language like this, that what you have are influence districts, which mean that you will lose minorities. And so I think for that reason, Mr. Chair, I will have to cast a no vote. Thank you.
Thank you. Is there further discussion? Senator Boysko.
So I just want to clarify, in order to do the analysis that's required by federal law, you have to use political data in order to do racial block analysis. So I just want to clarify that's why we would have that in there. I'm looking forward to supporting this bill. I appreciate the patron for all the hard work that she's done on this to make sure that it's the best criteria bill that we could have in Virginia. And I continue to say let's move and vote it.
Okay, is there further discussion? There was a motion to report and a second. Open the roll. All in favor, vote aye. Opposed, no. Who has Servel's? Okay, close the roll. The bill's reported. Okay, thank you, Senator McClellan. And the other criteria bill, Senate Bill 56 from Senator Suderline, Senate Bill 241 from Senator Barker, and Senate Bill 516 from Senator Edwards, and Senator 175 from Senator Chase are not in order anymore. We've got three versions of the constitutional amendment. Senator Barker, were you going to speak to that? The enabling, okay. Which bill, what's your bill number then, Senator Lucas? 203? Okay. Give your attention to Senator Lucas.
Thank you, Mr. Chairman. Members of the committee, as you know, we've been working on some form of nonpartisan redistricting for years, and as I recall, as far back as 10, maybe 15 years ago, you were introducing similar legislation yourself. And so what I'd like to just offer today is that the enabling legislation that will implement the proposed constitutional amendment passed on its first reading last year.
And Senator Lucas, I don't mean to butt in. You've got a substitute. Is that right?
That's right.
Yeah,
please offer substitute.
Is there a motion on the substitute? All in favor of adopting the substitute, say aye. Opposed, no. Okay, the substitute's before the committee, and I direct your attention to Senator Lucas. I apologize.
I also, Mr. Chairman, been a long day. But again, the enabling legislation that will implement the proposed constitutional amendment passed on its first reading last year to create an independent redistricting commission. This is a compromise bill in that there were several enabling bills introduced in the Senate and the House in this session. This bill will take the best parts of all of those bills, both Democratic and Republican, and combine them to create a comprehensive enabling act.
Okay,
One of
the other bills you're talking about are 204 and 975.
That is correct.
Okay.
One of the goals of this compromise bill was to ensure a diverse commission. Senator Spruill, did he hear me?
This speaks to Senator Spruill's.
Okay, I'm speaking to you. Got your hearing aid turned up. One of the goals, I'm sorry, but Mr. Chairman, I apologize. One of the goals of this compromise bill was to ensure a diverse commission that fairly represents all citizens in our Commonwealth. This bill does that. It requires that every authority involved in establishing the commission, from the Chief Justice to the Judges Selection Committee to our legislative leaders, all must take into account the racial, ethnic, geographical, and gender diversity of the Commonwealth, Senator Spruill. It is a comprehensive bill in that it supplements many of the details that could not be included in an abbreviated constitutional amendment. It prescribes strict timelines to ensure prompt action is taken in the recruitment and appointment of commission members, in scheduling public meetings, hearings, and in preparing maps to present to the General Assembly, all set to meet the tight deadlines required to hold our odd-year elections in a timely fashion. The bill sets forth detailed application procedures for citizen membership, with eligible requirements and qualifications clearly spelled out. It prescribes terms of office for commission members, a process for filling vacancies, and authorizes per diem compensation and reimbursement. The bill includes redistricting standards and criteria for drawing district criteria that will govern all maps drawn by the Commission, the General Assembly, and the court if it should come to that, Senator Spruill, if it should come to that. If it should come to that.
So your draft, okay. But this is what the constitutional amendment contemplates. This
Yes,
is the
sir, that is
commission.
exactly what it does.
So there'll be 8 legislators, 8 non-legislators, 2 from the minority and 2 from the majority from both the House and the Senate.
Correct.
Okay, and then the other 8, how are they selected exactly? Do you know?
I have my expert. Okay. Well, he and I have been glued at the hip for the last 2 decades trying to get some redistricting legislation passed. So Greg, help me out here.
Mr. Chairman, members of the committee, I'm Greg Lusick. I'm a retired attorney. I was in the Senior Assistant Attorney General and Chief Staff Attorney in the Supreme Court for the last 30 years. And I've focused on redistricting litigation and law during that entire career, pretty much. The citizen members of the commission are actually selected by a judges selection committee. And it's 5 retired circuit court judges that are selected pretty much by the General Assembly, majority and minority leaders. The Chief Justice sends you all a list of who the eligible retired judges are. The majority and minority leaders pick 4 judges from the list, and those 4 pick 1 more. That's the Judges Selection Committee. And the Judges Selection Committee sets up an application process where citizens who want to participate on the commission can apply. And it's a very detailed application, and in fact, Legislative Services will help process and prepare the application so it'll be ready to go. Meg is making a face because it's adding to her workload, but it's an important workload. And so citizens can apply and will be considered if they are eligible, if they meet all the requirements. You know, they have to, for the last 3 years, residents of the Commonwealth. They can't be political principals, members of the General Assembly, that sort of thing. They take as much as they can, the extensive partisanship out of it. That list of eligible people is then sent to the majority and minority leaders in the General Assembly. And each one of them gets to pick 16 citizens, if there are that many, that they would nominate for appointment to the commission. Their lists are sent to the judges, and the judges narrow that down to the 8 persons who will be appointed to the commission.
Mr. Chairman,
Senator Spruill's got a question.
Yes, sir.
the 8 that narrowed down to the judges, I want to make sure they all are not black and they all are not white.
That's correct,
And
Senator.
they are, I'm sorry,
No,
Senator.
you go ahead.
The judges are required to apply the same standard, and that is that they must give consideration to the racial, ethnic, gender, and geographic diversity of the Commonwealth. The Chief Justices are required to do that. And the legislators are required to do that in appointing legislators to the commission. So the diversity requirement is extensive and runs through every single phase of the process.
Okay, are there additional questions from the committee for Senator Lucas or Mr. Lucas?
I have a question.
Senator Vogel.
Just to clarify, this commission bill seems to have the similar or identical language, the criteria language included. So let me ask you this question. To the point of protecting racial minorities. Currently, under the Voting Rights Act, we strive to have minority districts so that people of color can be represented, they can win primaries, and they can be in the legislature. Under this criteria, that removes that, and what you have now are influence districts. Is that is the criteria now in this bill, correct?
Senator Vogel, I think
Because I guess the question is this criteria identical to the criteria that we just voted on, and for the same reason that I was concerned and objected to that? Okay.
Yes, indeed.
Because that would be my only objection. I have always supported, and I have carried over and over this same commission. I believe in a commission. I believe desperately that we need redistricting reform, and we don't want gerrymandered districts. But what I don't want is for us to conclude in the end, as some states have had happen, is that while we might have districts that have maybe more Democrats, but we have no minorities because you have no more minority districts, you have influence districts. And the United States Supreme Court has never said that influence districts are okay. And that's one of the major issues here is that we'll have influence districts, and we may not have the diversity in the General Assembly that we have now. So,
Okay, this bill just has the mechanics of setting up the commission plus the criteria that we just adopted.
right. But Mr. Chair, it does have that criteria, and I just want to point that out.
Yeah, you're exactly right.
Mr. Chairman?
Senator Eben, then Senator McClellan.
On line 515, it talks about establishment of districts in case the commission can't agree by the Supreme Court. And I had talked with Meg about the prospect of doing an amendment there about recusal by Supreme Court justices if they should be related to a member of the General Assembly. And that's largely to keep public confidence in the process. And I don't know, Meg, if I gave that to you or if you have it? Okay. Would that be in order to offer that at this time?
Amendments, now's the time when you're.
Okay.
Wait a minute, Mr. Chairman, you got to explain that a bit more. Would you mind doing that, repeating that, please?
Senator Spruill wants you to repeat.
Yes,
Senator
sir.
Spruill, his amendment would require a Supreme Court justice who is related to a member of the General Assembly from recusing themselves from any decision with respect to the redistricting.
Yes, sir. Thank you.
Okay? And that relates to one member.
Well, it could relate to future members.
It could relate to future members. Currently, yeah.
It's not intended.
Yeah. We're going to put Senator Peake's wife on the Supreme Court.
Mr. Chairman.
Senator McDougal.
So does the amendment that Senator Eben contemplate also include to other judges that are appointed, whether they might be related to other members of the legislature, the circuit court judges that are appointed?
That would be a friendly sub-amendment to just
He said he'd
insert
agree
that.
to that if you wanted a substitute amendment.
I was asking him if his amendment did that.
It did not, but I think adding a few words would do that, and I think that would be fine. That's a motion.
Second.
I would move my amendment with the addition of, if Meg can fit in a few words about the selection
It would
committee.
probably have to go in another part of the code, another part of the bill.
Maybe that should go by if.
No, we're not going to go by. Today's the last meeting before crossover. We're going to get, no.
Okay. I don't know if the amendment would be ready or.
So if we could start with the line amendment that we've already prepared for the Supreme Court justices, on line, well, after line 548, we'll insert a new subsection G, and it'll say any justice who is a parent, spouse, child, sibling, parent-in-law, child-in-law, sibling-in-law of, or cohabitating member of a household with a member of the General Assembly shall recuse himself from any decision made pursuant to this section, and no senior justice designated pursuant to Section 17.1-302 shall be assigned to the case or matter to serve in his place. And then I will look at some language for Senator McDougal's.
Mr. Chairman?
Senator Lucas?
Yes, sir. Could I please have my attorney respond to that amendment to see what, in fact, that does?
Yeah, Mr. Chairman, members of the committee, there's already on the books the canons of judicial conduct, which require a judge or justice to recuse themselves if they or any family member have more than a de minimis interest that could be substantially affected by any matter.
So, Mr. Rusick, what you're saying is that Senator Evans' amendment's already covered by the judicial canons.
Well, I would say that it is. I mean, again, recusal is always a matter of the judge's discretion, but these judges and justices exercise that significant, yes.
Mr. Chairman.
So I think.
Mr. Chairman, question for counsel, or I didn't get your name because I got here late.
Senator Survey.
I recognize that the judges can voluntarily choose to recuse themselves if they feel like they have a conflict, I guess subject to bar discipline or something, which doesn't seem to happen very often. But my recollection of what the amendment that counsel described was that it also said that should a judge recuse, that no retired judge could serve in their place. And that is not how the judicial canons work or the existing practice of the Supreme Court. Am I right?
I believe that's correct. They might ask a senior justice to participate, but.
Excuse me, further question, Mr. Chairman?
Senator Survey.
What do you mean might? I mean, they will.
Well, I
right?
don't think that the court does that all the time. I've seen cases where 6 judges have presided, 6 justices have presided. So it's not a hard and fast rule that a senior justice always participates. Generally, they do, but there's no requirement that they do.
But, Mr. Chairman,
Senator Survey.
sorry, but so can we agree that if this amendment were adopted and somebody were to recuse, or more than one were to recuse, then no retired judge could sit, period? It wouldn't be a maybe or a might, it would be definitely, right?
I would have to agree.
Okay, thank you.
Okay, I think Senator McClellan, did you want to speak to this issue or?
No.
Okay.
After the amendment.
So the amendment is before you. You want to report that again?
Sure. So on after line 548 of the substitute, we will add a new subsection G that reads, any justice who is a parent, spouse, child, sibling, parent-in-law, child-in-law, or sibling-in-law of, or cohabitating member of a household with a member of the General Assembly shall recuse himself from any decision made pursuant to this section, and no senior justice designated pursuant to Section 17.1-302 shall be assigned to the case or matter to serve in his place. And then to Senator McDougal's concern, a proposed amendment could be to add on line 257 of the substitute after committee the words, and no retired judge who is a relative, who is a parent, spouse, child, sibling, parent-in-law, child-in-law, or sibling-in-law of, or cohabitating member of a household with a member of the General Assembly shall be included on such list.
Okay, so those amendments make very clear.
Mr. Chairman.
Senator McDougal.
Mr. Chairman, as I'm reading down through the bill, I also noticed that there's some other language that I think starts on, in essence, line 310 that includes members of Congress. And would wonder why that would not be included as well. Or, Mr. Chairman, has been employed by a state, federal, local campaign. If you're going to make this exclusion, why are you not putting in all the other excluded items as well?
I would consider that friendly to add member of Congress. We already have It just says can't communicate.
Senator McDougal, if you've got an amendment, just propose it. Let's deal with the amendments before us right now. I think we both have a subcommittee at 5 o'clock that I'd like to be able to get to if we can. So Senator McClellan, do you have something on this?
I guess if his question is about members of Congress cannot, is your question about whether a member of Congress can serve on the commission? Because
No,
that's pretty clearly no.
Mr. Chairman, no. My question was about you're putting an exclusion to the member of the General Assembly who has a relationship to a judicial officer, but you're not doing that same relationship to a member of Congress who has a relationship to a judicial officer. That is my question. Why are you not doing that?
Because her uncle.
I'm very open, and I would consider friendly to add the words "or member of Congress"
In both places.
in both places.
Okay.
But it's not going to disqualify Sia. It's just, it's disqualifying the justice.
Are there those who would like to speak in favor of Senate Bill 203?
Senator Deeds and members of the committee, my name is Suzanne Franklin, and I am representing AARP Virginia. We support SB 203. Thank you.
Thank you, ma'am. Yes, ma'am.
Deb Wake, League of Women Voters of Virginia, we support it.
Thank you, ma'am. Are there people that have a contrary view? Okay, Senate Bill 203, the appropriate motion, if there is.
Mr. Chair.
I'm sorry, Senator Vogel.
I'm super sorry to do this. I would just like to ask, and I would hope that Senator Lucas might consider that this is a friendly amendment, but in the substitute bill, I think the original bill was merely the commission. And I don't think there's any dispute over the validity of the commission and the structure of the commission, and I think everybody embraces that. The addition of the criteria is duplicative of the criteria bill that we just passed and identical to that language. And so my question would be, would the patron be willing to strike the criteria section because we have the criteria vehicle, understanding that if ever there's an issue with the criteria or it's subject of litigation or there are challenges or we have subsequent discussions about it, can we not have a clean vehicle that's commission that moves forward and then have Senator McClellan's criteria bill, which will then move forward, and not have any issues of one taint the other? And I believe that that wouldn't in any way undermine your work because you still have the criteria identical in Senator McClellan's bill.
Senator McClellan's name is still on my chart. Do you want to address this?
Well, I was waiting to address something else, but I think, so my understanding was Senator Lucas's original bill did include criteria. So I think that's why she changed her criteria to mirror what is in mine. I think that would be fine to have a standalone criteria bill because it is written in a way that it applies no matter who is drawing the lines, but I'm going to defer to the patron of the bill as to what she wants to do.
Well, my question is, what is the harm in having it in both places?
Mr. Chair, if I may,
Senator
I
Vogel.
think as long as we have Senator McClellan's criteria bill that moves forward and applies no matter what, whether a judge draws it, whether the legislature draws it, whether the commission draws it, then there is no harm in excluding it, but there could potentially be harm in having criteria in the underlying vehicle of the commission that is just the commission. And then there's no controversy about the commission. There's no concern, no challenge. Then you're not challenging. The commission itself is not subject to any of the challenges that might later arise related to any other part of the bill. Then you have a clean commission bill that moves forward. And I think that doesn't undermine either of the efforts. And I think would be my preference, and I think probably
Mr. Chair,
Senator McClellan.
I'm gonna make a suggestion, given the lateness of the hour. I think that we should move forward with her bill, with the criteria in it, with a commitment that we will confer, and if the senator is amenable, we can do a floor amendment to take it out. I think, given the lateness of the hour, I think she's probably gonna wanna confer with a couple other folks that she worked with on this legislation to make sure they're comfortable doing that. So that would be my suggestion.
Okay.
That is correct. I support that recommendation, Senator McClellan, because I'm not the only person who sat in that room until almost midnight,
Okay.
several weeks, working on this. So,
Senator McClellan, did you have something else?
I did. I just wanted to respond very quickly to one thing that Senator Vogel said about the Voting Rights Act, and that is to clarify the Voting Rights Act was not intended to ensure a particular number of African American or minority representatives be elected. What the Voting Rights Act says, and what the case law makes clear, is that the minority communities have an opportunity to elect the candidate of their choice. And as a matter of fact, in the congressional redistricting lawsuit, part of why the congressional districts were struck down was because of the high number of African Americans who were packed into the 3rd district.
that's correct.
So that, and diluting their power in contiguous districts, which is why we now have more congressional representatives of color than we would have under that original bill. Same thing happened in the House. So I want to make sure that the record is absolutely clear that packing African Americans into smaller number of districts to guarantee election in those districts and thereby diluting their power in other districts actually leads to fewer African American members.
That is correct.
Than doing the other way around. And
That
I
is
just want the
correct.
record
Mr.
to be
Chair.
clear on that.
Senator Vogel wants to respond.
Mr. Chair, if I could just respond to that. To be clear, what I was talking about was the fact that this bill moves beyond the notion that you are able to have your candidate of choice, which if you have a majority-minority district, it is much more likely that a minority community will be able to elect their candidate of choice. Once you get to influence districts where the population is dispersed, it is often less likely that you will have a minority candidate. And to date, the Supreme Court has not said that sort of undercutting might not be the right word, but changing the application of the Voting Rights Act and moving to influence districts has been okay. And it does have an impact on minority representation.
Mr. Chairman,
as a fact.
I move the bill be
Senator Bell.
approved as amended. You can be here past 5 o'clock to keep talking.
I understand that. People want to keep talking. That's their right.
Well, you can cut them off, too.
Okay, well, let Senator Bell.
I'm sorry,
wants to
Mr.
talk.
Chair. I'm happy to
That's all right, Senator Vogel. I appreciate your wisdom. Senator Bell.
Mine is very brief, and I think this has been covered, but I'm going to ask if as we go forward on the criteria, if council could just do a word check to make sure it's verbatim between the two if we take one out, because if one is different from the other, we could have a problem. Or if we take one out, I want to make sure that nothing is left out of the other one.
That's a good suggestion.
Now,
Senator Boyce, go.
Thank you, Mr. Chair. I just want to reiterate, I think it's really important that we keep the criteria in Senator Lucas's bill that enables, so that is very apparent without separating anything out, that this is what we expect as legislators, that we are going to follow the criteria that she has set that goes right along in the enabling legislation. I'm not comfortable taking that out. I think we should move forward, and I don't think there's a problem with having the secondary bill moving forward at the same time.
Okay, I think Senator Spruill had a motion.
But Mr. Chairman, before Senator Spruill makes his motion, I just want to say, keep in mind that there were a lot of people from the House and the Senate that worked jointly on putting this together who wants to see this criteria in this bill. And I don't have a problem with the separate criteria bill going forward, but a big part of how we got as many people to come to an agreement as we did was because the criteria was in this bill. And without the criteria, my fear is that we'll end up with nothing if it's not in this bill.
So I move, Mr. Chairman, that we report the bill as amended.
And refer it to finance. Okay,
And
is
refer
there a
to
second to
finance.
motion? Is there a second to that motion? Okay. Okay, all in, and, oh, please open the roll. All in favor, vote aye. Opposed, vote nay. Okay.
Thank you, Mr. Chairman and members of the committee.
The bill is reported and referred to finance. The constitutional amendment there. Thank you, Senator Lucas.
You have no idea how grateful I am. This has been my best legislative day in a long time.
The constitutional amendment.
Mr. Chairman. Mr.
Senator
Chairman,
McDougal.
I know the chairman does not believe that certain bills are in order, but we don't have that as a motion. So there needs to be a motion to report or to PBI those. There's no provision just to rule them out of order. So I'm happy to move that the ones I like be reported, which that motion would be to report Senate Bill 56. But,
Okay,
we've got to take some action on them one way or the other.
In a block of the criteria bills, the enabling legislation bills that we didn't pass, I'd like those listed in the block, and I'd appreciate a motion to PBI.
Mr. Chairman, can we have 56 come out of the block? Because I think that I want to vote differently on all the rest of them.
Okay. Okay, is there a motion to PBI all of the criteria bills and
Mr. Chairman?
Yes.
I would move that all the criteria bills except for
56.
56 that were not already passed come out of the block for the purposes of PBI.
Okay, and those bills are 50, or that's 241, 516, 175, and then 204, 975. Okay, and they're all, the motion is to PBI those bills. All in favor, vote aye. Open the roll, please. Okay, those bills have all bitten the dust. You have a motion on 56.
I'd move to report it, and then you can just flip the vote.
Okay.
Second.
Want to do a substitute motion?
I would make a substitute motion to PBI.
Okay.
Call the previous question.
Okay, all in favor of calling the previous question, vote aye.
We're doing, Jan. Green.
That was a no for the Democrats.
Okay,
I had 6 noes and
the
9.
previous question is not ordered. The motion is to PBI 256. All in favor, vote aye. On Senate Bill 56.
I has
Okay.
9, no 6.
The bill is PBI'd. Senate Joint Resolutions 12, 18, and 70. They're all the same. Yes. So they're going to be rolled into Senator Barker's. I think you wrote the bill last year. It's exactly the same form it was last year. Is that correct? Okay, and again, that bill's been requested by the Finance Committee, so the motion would be, we've heard this before. If there are people that feel a real itch to stand up and speak in favor or against it, you're welcome to.
Mr. Chairman, move the report and refer to finance.
Okay, we have to incorporate 12 and 70 into 18 first.
So move, Mr. Chairman.
Okay. I'll open the roll, please. Okay, do we need separate motions on each bill to incorporate each one? Okay, they're both incorporated into Senate Joint Resolution 18. Then the motion to report and refer to finance would be in order.
So move, Mr. Chairman.
Okay. Open the roll, please. All in favor, vote aye. Okay. The bill is reported and referred to finance. Then we have the ballot question. And the first order of business is to incorporate, that's also, we have three bills, and I guess they're all identical. The first would be to roll 358 and 974 into 236. Do I have a motion?
So move.
Okay. All in favor, vote aye. Open the roll, please. Okay, so 236, the ballot question, are there questions about that? Or do you want to make a presentation of that, Senator Barker?
Not really.
Okay.
Mr.
I'd be happy to answer any questions.
easy,
Mr. Chairman, you move the report.
Report and refer to finance.
Mr. Chairman?
Yes.
A quick question. It's kind of lengthy. Is this what goes in the brochure or on the voting machine?
It's what goes in I guess, it's the vote, it includes the question that goes in the voting machine, but it also includes information that goes in the voter explanation. Is that correct?
No, Mr. Chairman, Senator Eben, the sort of odd way that we do voter referendums is we first set out the amendment itself, and then you can look on page 3, lines 129 through 133 is where we will actually have the question, and that's the question that will appear on the ballot. We'll take up the ballot explanation to approve at a later date, usually around reconvene. But for purposes of what's on the ballot, it's the question that's on lines 130 through 133.
Okay, great. I would move to report.
Report and refer to finance.
And refer to finance.
Okay, is there a second? Okay. Anybody burning to speak to that? Okay. You know, I got something I want to say about all these bills, but let's get them out of the way first. Okay. Now, okay, the bills reported and referred to finance. I voted for these bills, and I applaud all the work that's gone into them, and I know lots of people from lots of different points of view had input in this process, and I appreciate you all. You know, I carried legislation from 2002 until last year on redistricting reform. In my view, this commission is flawed in at least 3 respects. Number one, the big one, the constitutional amendment did not have the criteria in it. That means it's going to change every 10 years. You know, and I think the criteria, whoever draws the lines, the criteria is the most important part of it.
That is exactly right.
And that should have, I mean, in a perfect constitutional amendment, and the perfect is not going to be the enemy of good. It wasn't the enemy of good with respect to my vote. But the criteria, a perfect bill, the criteria would have been in the constitutional amendment. The second thing, the second flaw that I see in it is that, you know, I like to stand on the mountaintop and say that when legislators draw lines, there's a built-in conflict of interest because we want to protect our own hind parts, in the words of my friend Senator Sproul. But the reality is this commission is half legislators, half non-legislators. So the legislators are still in the kitchen where the redistricting lines are being cooked. The third flaw, as I see it, is that again, it relates to the second because the amendment, the process comes back to the General Assembly for approval. So I would rather have a constitutional amendment that took the legislators completely out of the process. And I've got friends on both sides of the aisle that disagree with me on that. And that's okay. But the amendment's passed. I hope everybody's happy. We've got Senate Bill 74, which is my bill.
Mr. Chairman, maybe we should take that all back again and...
No, it's done. It's done. Okay. Senator Eben, I want you to chair for a second. Senate Bill 74, I've got a substitute for that. And I'd appreciate a motion to adopt a substitute.
Chair from over here.
Yeah, you can chair from there. Okay. Mr. Chair, you know, about 3 years ago, I think I was in Chicago or Seattle at an NCSL, and we were talking about electoral reform, and I was impressed with a presentation from Utah where they had same-day registration. And so I've carried legislation for 2 or 3 years that would create a pilot project for same-day registration, or for election day, you could register and vote the same day. If Utah can do it, I thought we could do it. But I was concerned about the cost of it, so I had a pilot project. Well, some people raised with me concerns about the pilot project. They said you'd create equal protection problems with a pilot project because you'd have different election rules applying in different parts of the state. So the bill before you has statewide same-day voter registration, but it has an enactment clause. It's not effective until 2022. So it buys us a couple of years to figure out what it's going to cost and to make changes if it's not going to work for us.
Mr. Chairman?
Well, I don't think it's been requested by, has it been requested by Finance? It has not. Probably because it doesn't have cost until 2022.
Everything else go upstairs to finance on what? So what's the difference?
The difference is, I'm sorry.
This is based on whether or not finance has requested a letter based on their determination and their wisdom or not, or lack thereof. Senator Deeds, can I ask you two questions?
You sure can.
Is this apply for General Assembly elections that take place in multiple localities?
It would apply statewide beginning in the 2022 elections.
And have you spoken to the Department of Elections about this?
I have not. The reason I had it drawn as a pilot project in the first place was I was concerned about the cost of it. And I thought if we did it on a pilot project, we can figure out what the logistics were going to be and what our costs would be. But the concerns were raised that we'd create an equal protection problem by doing that. We'd have one set of election rules applied one place and not other places, and that we might be better off to adopt a statewide approach. And that's why that's what the substitute does. But because there are likely to be some logistical issues and some cost issues, we've put off the effective date until 2022.
Mr. Chairman?
Yes, sir.
Yes, Senator.
I'm sorry. Why in the world, now I won't support this, when we have an election statewide, you got the newspaper, the candidates going around knocking on doors, going to churches, on TV. So why in the world we wouldn't do it on the same day? On the same day, you're going to tie up the registrar's office, number one. It's going to cost more money, number two. They're going to need more staff. If everybody knows that there's an election next week, for example, you mean to tell me why in the world they wait till the day of the election to be registered?
Mr. Chair.
And Mr. Chairman, so I'm not for the all we're doing then is just time. And if we have problems, I would like to use Chesapeake, the Comfort Center, for an example. For example, the Comfort Center, that's the one that every 4 years they make national news. That's the one that the precinct at 7 o'clock, which is my district, I love it. At 7 o'clock, you still got 800 people in line waiting because the register does not have enough people inside to work. Now, you got to deal with that. You don't have enough people who want to do the job anyway, and now you got to work somebody on election day. Why in the world would I wait until election day, knowing there's an election on the first Tuesday in November? Why do I want to wait until election day to go out and vote? And all this doing is tying everything up and cost money. So I'm voting against this.
Well,
thank you, Senator. Deeds.
Mr. Chair, I would say to Senator Spruill that states that have done this have seen a 5 to 10% increase in voter participation. And if Utah can do this,
it's nobody in Utah.
Yep.
Okay. I'd like to, if I might, ask the Department of Elections if they're here, 2 or 3 questions, if you want to come up. I would first ask if our elections, if we're equipped to do this, if we can be equipped by the enactment clause of October 1st, 2022.
Thank you, Mr. Chairman. Jessica Bowman, Deputy Commissioner, Department of Elections. We could be, yes. And there is, council can correct me if I'm wrong, there's a House version of this bill as well. Is it the same?
That's correct. It's an appropriation, so,
Okay, and if I might ask 2 more questions. One is there a concern about security and hooking up precincts to the internet with what's going on in recent years?
Mr. Chairman, I would say that security is always a concern. When we have time to look at this over the next 2 years, we can either A, mitigate those concerns, or B, I think the original bill had a paper process that you would go through, and it wouldn't be hooked up. It would be provisional. So you could fill out a voter reg form, do a provisional, and then the voter registration would count the GR deemed so. So if we get into a place in the next 2 years that we're too worried about security, there are other ways to do it. As Senator D said, many, I wouldn't say many, but more than Utah does this, and they do it well. So if they can do it, I'm sure we can figure it out.
Okay, and are there members of the committee who have additional questions?
Mr. Chairman, speaking of the bill.
Yes, sir.
Just briefly, I'll say 21 states do this now. It's been going on for a long time. It's been very successful in increasing voter turnout and I think giving people a chance to not be disenfranchised where they're turned away when they get there. So I am in support of this legislation, and I'll be ready to make a motion at the appropriate time.
Okay, and we have Senator Boysko as well.
Mr. Chairman, thank you so much. I served as a precinct captain for 15 years before I became an elected official. every single year, every single election, there are several people who show up thinking that they can register at the polls right on election day and then leave disappointed. I know that in, our communities, people are busy. They don't read all the, the requirements sometimes, especially those young folks who are eager to vote for the first time. And I think this is a reasonable and looking forward to supporting this bill.
Okay, and if there's members of the public who would like to speak for the bill?
Hi, my name is Jennifer Safstrom with the ACLU of Virginia, here to support the bill. This process has been in existence in 21 other states for over 40 years, and it's time it comes to Virginia in order to increase enfranchisement and access to the polls for individuals who have family obligations and may not be able to comply with a deadline 21 days ahead of time, who may not realize there are issues with their registration and show up on day of and aren't able to vote as anticipated. And so this bill would help ensure that all of those individuals have access. So the ACLU encourages support of SB 74 as we do. Thank you.
Thank you.
Yes, Mr. Chairman, members of the committee, Carol Nagle with the League of Women Voters. And yes, we certainly want to take care of hurdles for registering to vote. So we support this, and we do have time to implement it and find the best way to do that.
Thank you.
Thank you, Mr. Chair. Anna Scholl with Progress Virginia. We support the bill and believe it's an important step to making our elections more accessible. Thank you.
Thank you. And any who would like to speak against the bill?
Liz Martin, City of Winchester. Thank you for listening to me. I'm speaking, I guess, this is my personal thought that I have concerns about this, so I'm not really technically speaking on behalf of the Voter Registrars Association, but I just can't see how this looks like such a huge challenge to me. I'm just not sure we can do it effectively. I know the staff that I would have to put at the polling place, I would think would be having to increase probably, say if my typical polling place has 8 to 10 officers of election, I'd have to go to 12 to 15 at each polling place just to handle the crowd. And the states that I've seen do this, they have like a 2-hour wait for the registration and then another 2-hour wait to vote, and then they don't understand why they have a 2-hour wait to vote, but it's because you don't have the staff or the voting machines or the space for the quantity of people you're having coming into the polls. So those are just some of my concerns. So maybe with 2 years out, we would have that, but I have some real concerns on how I would implement it right now.
Thank you.
And the cost.
Okay.
Clarabelle Wheeler, Albemarle County former electoral board and unit chairman for a precinct. I would reiterate what Senator Spruill said. If you've got an election coming up on November or a primary or any election, you should be paying attention, and you know it's coming up. We've got extended voter registration dates. We have no excuse voting coming up. There's no reason why you should come to a polling place on Election Day and not be registered if you're paying attention. You've heard from a registrar telling you that this will be a physical impact. We have trouble right now getting election officers to serve on Election Day. And now we're going to have to find people not only to be election officers, but to register people on Election Day. And yes, she's right. Other states have huge waiting lines. We'll compound those waiting lines because we will not have enough people to serve the needs of the voters when they could go to the registrar's office or fill out early on in the registration period. We also will have an expense for this, and I would offer that the physical impact on this, I hope you will realize, may fall to the localities, but it's still the people paying for it somewhere. And we will have no means of checking whether somebody is already registered in another precinct where they should be voting and where they could vote, because we will not be able to, or we will have trouble loading onto Verus the registration system with all of these precincts all over Virginia piling on. I think it would be a major miracle if Veris didn't shut down on Election Day, which would be catastrophic. Thank you very much.
With that, Senator Deeds, would you like to follow up?
Just to wrap up, 21 states do this. If they've figured out how to resolve the cost issue and how to, I don't read about too many 2-hour waits in a lot of those places. I mean, I don't know. I know Virginia. I don't know these other states. But I know that in the states that have implemented this, they see 5 to 10% increase in turnout. And that's significant. We ought to be about encouraging people to vote. And this encourages more people to participate in the process. We live in a place where we have people that introduce bills to require party ID for constitutional officers, for crying out loud, and voters aren't paying attention. So you have to give them information. So why can't we allow people to register to vote on Election Day? With that, I'd move we report the bill.
Okay. There's been a motion and a second. All those in favor will vote aye on the electronic voting board. And there are...
Ayes 7, noes 8.
Okay, the bill fails to report.
Then we'll rise, and we will see you next meeting.